Hello and a warm welcome to Well This Week by latestlaws.com. This is a weekly program, so hit the bell icon to get notification for new videos. My name is Sheetal Joon, Associate Editor, latestlaws.com, and let's begin with Supreme Court this week. This week, in a significant decision, the Supreme Court has ruled that the armed forces can take action against their officers for adulterous act, and decriminalization of adultery would not stand in the way of initiating disciplinary proceedings. Observing that military discipline will be affected if there is an army with completely loose morals, a 5-judge constitution bench headed by Justice K.M. Joseph clarified that its landmark 2018 judgment, which had struck down Section 497 of the Indian Penal Code that criminalized adultery, was not concerned with the provisions of the Armed Forces Act. The court in 2018 had struck down the 158-year-old anti-adultery law, saying it was unconstitutional as it dented the individuality of women and treated them as chattel of husbands. However, the bench, also comprising Justice Ajay Rastogi, Justice Anuruddha Bose, Justice Harishikesh Roy and Justice C.T. Ravikumar, remarked that it is not as if the court has approved of adultery. In another notable ruling, the Supreme Court has observed that whenever Section 156(3) Criminal Procedure Code gets misused by the litigant to give criminal color to civil disputes, the power under Section 482 Criminal Procedure Code can be exercised to quash the same. The division bench of Justice Ajay Rastogi and Justice C.T. Ravikumar in this view quashed the case against the appellant after assessing that application filed under Section 156(3) CrPC didn't satisfy the essential ingredients to attract the alleged offences and adjudging the allegations as vague. The court also found out about the suppression of pending civil application in the matter. It concluded that the respondent have given a clock of criminal offence in the issue, and in circumstances when the respondent had already resorted to the available civil remedy and it is pending, going on by the decision in Paramjit Patra, the High Court would have quashed the criminal proceedings to prevent the abuse of process of law, but for the concealment. The Supreme Court has directed all the courts and judicial forums to frame guidelines to ensure that amounts deposited with the offices or registry of the courts or tribunals are mandatorily deposited in a bank or financial institution. The division bench of Justice M.R. Shah and Justice S. Ravindra Bhatt issued the direction to make sure that litigants do not suffer any loss of interest on the amount deposited before the courts. It was additionally stated that the guidelines should also cover situations where the concerned litigant merely files the instruments such as pay order, demand draft, banker's check, etc., without seeking any order. The litigant in the present matter was up against a builder over delay in allotment of flat despite receiving installment payments. Although the court adjudged her appeal as plainly untenable, it brought into discussion the common issue facing litigants with regard to deposit made with the court as matter of their rights. Disapproving the Allahabad High Court dismissing 50 bail applications for default or non-prosecution in a single day, the Supreme Court has dispatched such practice. The division bench of Justice Ajay Rastogi and Justice Bella M. Trivedi, while adjudicating upon an appeal challenging one such dismissal, has sought report from the registry underlining reasoning for the High Court judge's decision to dismiss about 45 bail applications on the same day for default in the same fashion. In the affidavit filed, the registrar shared the details regarding the particular application and how the non-appearance of the petitioner resulted in the dismissal. The appellant, however, placed on record almost 50 orders passed by the court on that day in similar fashion, to which the court noticed that they are in fact in the standard format. The Supreme Court has opined that all courts in the country need to have hybrid system of hearing in place so as anyone from anywhere can appear before it. A bench of Justice S.K. Cole and Justice Abhay Oka expressed orally that there needs to be a mandate to courts to put in place the facility. When Senior Advocate P. Wilson said that regional benches of Supreme Court are necessary for the benefit of the litigants, the bench responded that with the growing technological advancements, this has become an outdated concept. The Supreme Court has kept the hybrid option, which gained popularity and became mainstream during the Covid-19 pandemic, in place until now. It provides the advocates and litigants with the option to appear via video conferencing rather than marking physical appearances. Certain high courts too have continued it, while the others have paused the plan, such as Bombay High Court and Gujarat High Court. Justice S.K. Cole, who is highly impressed with the system, called it a great facility. Next we have Delhi High Court. The Delhi High Court has reiterated that COVID-19 vaccines cannot be insisted upon by the employer. Finding consonance with Supreme Court and one of its earlier decisions, the court stated that bodily integrity is protected under Article 21 of the Constitution and no individual can be forced to be vaccinated. Further, the personal autonomy of an individual, which is a recognized facet of the protections guaranteed under Article 21, encompasses the right to refuse to undergo any medical treatment in the sphere of individual health. However, in the interest of protection of communitarian health, the government is entitled to regulate issues of public health concern by imposing certain limitations on individual rights which are open to scrutiny by constitutional courts. The Delhi High Court has expounded that inability to produce documentary evidence to show monthly income, the same does not justify the adoption of lowest tier of minimum wage while computing the income. The single judge bench of Justice Rekha Palli stated it while adjudicating upon an appeal under Section 173 of the Motor Vehicle Act 1988 filed by the insurance company challenging the award passed by the Motor Accident Claim Tribunal, contending that the respondent was residing in Uttar Pradesh and therefore the minimum wages payable to a skilled person in Delhi could not have been taken as a yardstick for the grant of compensation to him, that too when he had not furnished any proof of his income. The Delhi High Court, while dealing with an execution petition for enforcement of a final arbitral award, summarized that a challenge to an arbitral award on the ground of nullity and illegality can only be addressed in proceeding under Section 34 of the Arbitration and Conciliation Act. That would be the only remedy available to the judgment debtor. The court highlighted that the point that the Act neither envisages nor sanctions a dual or independent challenge to an award based on the various facets of nullity and illegally recognized being late in enforcement proceedings. The Delhi High Court directed the Delhi Chief Secretary to hold a meeting with other authorities to discuss a comprehensive resettlement plan for the Tughlaqabad village residents who are facing an eviction notice for illegally encroaching land in the Tughlaqabad fort area. The court passed the order after Delhi government's council submitted that they intend to rehabilitate and provide alternative accommodation to those living in the Tughlaqabad fort area with the help of land owning agencies. The court was hearing a final petition filed on behalf of more than 1,000 families residing in the Tughlaqabad village who were served with notices by the Archaeological Survey of India on January 11th regarding the removal of illegal occupants of houses in the Tughlaqabad fort area by January 26th. The Delhi High Court has asked the Insurance Regulatory and Development Authority of India to consider manner in which health policies can be designed for persons with hearing disabilities and persons with implants. The single judge bench of Justice Pratibha M. Singh, while adjudicating upon a writ petition challenging the denial of a health insurance policy to a minor who was suffering bilateral hearing loss, insisted that IRDAI, while submitting its position to the court, shall also consider the existing policy and guidelines as may be applicable to persons with disabilities. Now let's see an overview of other high courts. The Gujarat High Court has ruled that details regarding remuneration of High Court judges cannot be sought under Right to Information Act. The single judge bench of Justice Biren Vaishnav in this view set aside State Information Commission's order directing disclosure of the salary and allowances of a former additional judge of the Gujarat High Court under the RTI Act. The respondent had been denied the answer by the Public Information Officer who invoked provisions of Section 81J of the RTI Act and stated that it was personal information having no relationship with any public activity. The Guwahati High Court has observed that insurance company cannot be absolved of the liability to pay compensation in cases where the driver of the offending vehicle possesses a fake license. The single judge bench of Justice Arun Dev Chaudhary, while adjudicating upon an appeal by insurance company against MECT order on the ground that the award ought to have been made payable by the owner cum driver of the vehicle as it is established that he was possessing fake driving license, reiterated Supreme Court ruling in National Insurance Company versus Swaran Singh, wherein it was observed that mere absence, fake or invalid driving license or disqualification of the driver for driving at the relevant time are not in themselves defenses available to the insurer against either the insured or the third parties. It was also observed that to avoid its liability towards the insurer has to prove that the insured was guilty of negligence and failed to exercise reasonable care in the matter of fulfilling the condition of policy regarding use of vehicle by duly licensed driver or one who was not qualified to drive at the relevant point of time. The Madras High Court has held that mere presence of penal consequences doesn't exempt trademark suits from being referred to pre-institution mediation as mandatorily required under Section 12A of the Commercial Courts Act. The single judge bench of Justice M. Sundar in this view rejected the petition for leave to sue filed by Archie Spices and Foods in a suit seeking an injunction restraining the respondents from using trademark names or similar sounding expressions in any media, websites and other platforms. It was contended that in copyright and trademark statutes, infringement is not just a civil wrong but it has penal consequences also, and therefore urgent interim injunction was needed. The court called the argument as non-starter quas section 12 of CCA and observed that if there is a penal consequences and if there is a provision for proceeding for alleged criminal offence, nothing prevents the plaintiff from restoring to the same. That by itself cannot justify non-compliance with section 12A of the CCA, the court ruled. Another single judge bench of the Madras High Court has notably ruled that a wife cannot be attributed as a creditor and therefore held that husbands cannot claim exemption of pension from attachment towards payments of arrears of maintenance. The court observed that maintenance allowance granted to wife cannot be considered as a debt as it is a measure of social justice specifically enacted to protect and inhibit neglect of women, aiming to prevent vagrancy and destitution in light of the mischief to be avoided, the justice to be advanced. The court stressed that the lawful claim to a woman in distress should not be denied hurtlessly and lawlessly, and the conscience of social justice, the cornerstone of the Constitution, will be protected. The petition of wife of a retired barber from Indian military who had sought attachment of his pension from areas of maintenance was dismissed by the judicial magistrate on the ground that there is a bar under section 61G of the Civil Procedure Code. The Uttarakhand High Court has expounded that there is no statute or government order providing that a girl belonging to OBC category has to obtain OBC certificate on the basis of income of her husband immediately after her marriage. On the confusion that whether caste will be decided on the parents' caste or after marriage, husband's caste, the court clarified that caste status is acquired by birth and not by marriage. Thus, a girl who does not belong to other backward classes will not get benefit of reservation available to the OBCs merely by marrying a person belonging to the OBC. The Calcutta High Court has opined that merely because the individual parts of the claim are known or obvious when considered separately is not a ground to categorize the inventions as obvious. Instead of considering it partially, the whole invention has to be seen. The court expounded that the conclusion that any invention is obvious must be reached with care, caution and precision. Moving on to miscellaneous news. In the latest budget session of 2023, the Modi government has increased the personal income tax rebate to Rs 7 lakh per annum in the new tax regime. The income tax rebate is part of 5 major announcements made by the Finance Minister Nirmala Sitharaman. Out of the 5 tax relief measures, 4 were meant to specifically for the new tax regime, which means the government is trying to attract more taxpayers towards the new regime. Although government has made the new tax structure a default tax scheme, those who wish to continue with the old tax regime are allowed to do so and can continue to avail exemptions under Section 80 of the Income Tax Act. The Orissa High Court has notified scheme to confer Lawyer of the Year award on advocates who instill with themselves virtues such as etiquette, reputation and integrity. The scheme that was initiated last year aims to encourage young lawyers practicing in district judiciary, including outlying stations, to build up their performances. The award shall be conferred on 28th April, which is observed as Lawyers' Day every year in the state of Orissa to commemorate the birth anniversary of Utkal Gaurba Madhusudan Das. The schemes were notified list out details such as features of the award, eligibility to apply, jury, selection criteria, etc. The Prime Minister's Citizen Assistance and Relief in Emergency Situations PM CARES Fund is not a public authority as defined by the Right to Information Act, and therefore the trust does not come under its provision, the central government has told the Delhi High Court. In a detailed affidavit submitted to the court, the centre has said that PM CARES Fund has not been created under the Constitution of India or by any law made by the Parliament or state legislature. The Supreme Court Division Bench of Justice CGI D.Y. Chandrachud and Justice P.S. Narasimha has listed the matter mounting challenge to the Electoral Board scheme for final hearing in the 3rd week of March. The bench also clarified that 2 others petitions, one raising the issue of bringing political parties under the Right to Information Act and the other regarding certification under Foreign Contribution Regulation Act for political funding, are distinct from the Electoral Board case and will be heard separately. Notices have been issued in both the matters and the court has posted them to April for consideration. Electoral Board scheme was introduced through Finance Act 2017, which in turn amended 3 other statutes, the RBI Act, the Income Tax Act and the Representation of Peoples Act, for enabling introduction of such bonds. Various petitions challenging at least 5 amendments made to different statutes through Finance Act 2017 has been filed on the ground that they have opened doors to unlimited, unchecked funding to political parties. In an interesting instance, Bombay Lawyers Association, a voluntary body, has filed a public interest litigation before the Bombay High Court seeking direction to declare that the Vice President of India, Jagdeep Dhankar, and Union Law Minister Kiren Rijiju are disqualified from holding their constitutional post by showing lack of faith in the Constitution of India by their conduct and utterance made in public. As interim orders, it seeks that the High Court restrain them for discharging their official duties. The association has also sought to restrain the Vice President and the Minister from making derogatory, insulting and objectionable utterances showing their lack of faith in the Constitution of India and the judiciary established by the law. Another PIL has also been filed in the Supreme Court seeking probe against Hindenburg, the US short seller, accused Indian business tycoon Gautam Adani of corporate fraud. The top court has been urged to issue a direction to the Centre and SEBI to conduct an inquiry against the short seller for exploiting and dumping lakhs of innocent investors and to prosecute them. 7 listed Adani Group companies have lost more than half of their market capitalization, which shriveled to less than $100 billion after a report by Hindenburg Research questioned the conglomerate's debt levels and use of tax havens. In the end, we have international news. Notorious Colombian cocaine dealer known as Otoniel has pleaded guilty to drugs charges in the US court. Otoniel was the leader of Colombia's most powerful criminal gang for more than 9 years. He was arrested in his Colombian hideout in October 2021 and was extradited to the US last year, where there was a bounty for information leading to his capture. The 51-year-old has agreed to hand over $216 million in drug proceeds. Otoniel pleaded guilty in running a continuing criminal enterprise as well as drug smuggling and distribution charges. Italy's top court has ruled that children are under no obligation to see their grandparents if they do not wish to do so. The ruling from the Supreme Court of Cassation relates to an appeal by the parents of 2 children against the decision of a lower court which had forced the youngsters to spend time with their paternal grandparents. The year-long case was triggered by the grandparents and a paternal uncle who took action at the juvenile court in Milan, complaining that they were unable to meet the children due to the obstacles established by the parents, with whom they were embroiled in a family conflict. Thank you for watching and have a nice day. This is a weekly program, and to get more information, please check the description box, and for weekly updates, like and subscribe to our channel.